Bill C-12 has now become law in Canada. On March 26, 2026, Bill C-12 received royal assent and became law, which is meant to strengthen Canada's immigration and asylum systems. There were four key areas highlighted during that announcement. The first one is new eligibility requirements for asylum claims. The second, a modernized asylum process. The third one is domestic information sharing between countries. And the last is immigration document and application authorities. Now, I'm going to dissect these four key areas in details for you. Let's start with the first one, new eligibility requirement for asylum claims. We all know that Canada's asylum system protects people who can actually demonstrate that they face a real risk of persecution or serious harm from their home country. Note, if you have made an asylum claim on or after June 3rd, 2025, two new eligibility requirements are now in effect and will apply to all claims that were made on or after June 3rd, 2025. The first one, asylum claims that were made more than 1 year after someone's first entry into Canada, made after June 24, 2020, will no longer be referred to the Immigration and Refugee Board of Canada, which is short for IRB. So regardless of whether the person has since left Canada and returned, this is going to be in effect. The second one is that asylum claims that come from people who enter Canada between port of entry along the Canada-US land border and who make a claim after 14 days will no longer be referred to the IRB. They're saying that this new eligibility requirement is going to reduce pressure on the asylum system and protect it against sudden increases in all these asylum claims. It will also close loopholes and deter people from claiming asylum as a shortcut to regular immigration pathways when they know fully well that there are other immigration pathways that they could actually apply and they could qualify for. That's the reason why they are making sure they are doing this and putting things in place right now. Guidance is going to be provided to all officers so that they can consider individual circumstances of minors who are not accompanied, so unaccompanied minors, given that they lack legal guardianship. So that information is for those who have unaccompanied minors. People who are affected by these new rules, they will still have access to a pre-removal risk assessment, which is short for PRRA or PRA, to prevent them from being sent back to a country where they face risk like persecution, torture, or other harm. There is really no change to the application of the Safe Third Country Agreement. Now, for those of you who are not even aware, the Safe Third Country Agreement, its rules stay the same. It doesn't change. People who make a claim at a port of entry along the Canada-US land border or within 14 days of irregular entry, they will continue to be returned to the US unless they qualify for an exception or an exemption. The second key area mentioned was a modernized asylum process. Over the next coming months, Canada is going to improve how they receive, process, and decide on asylum claims by updating the Immigration and Refugee Protection Regulations. Now, these changes is going to achieve a whole lot of things. Let me mention them. Simplifying the online application process and thereby reducing the need to answer duplicate questions and complete multiple forms at the same time. The next one is referring only complete and schedule-ready claims to the IRB so that they can speed up the decision-making process. Another point is it will help to ensure that the IRB decides on claims only while the claimant is physically present in Canada, and if a claimant voluntarily returns to their country of alleged persecution before the IRB has made a decision. their claim would be considered to be what? Abandoned, because they are not in the country. The next point is that it will help to remove inactive cases from the system, which in my opinion makes so much sense. Another point is that it will help to speed up voluntary departures by making removal orders to be effective on the same day that a claim is withdrawn from the IRB. It will also help vulnerable people like minors or those who even don't understand the process by helping them to appoint a representative to support them during certain Immigration, Refugees and Citizenship Canada and Canada Border Services Agency proceedings, because they need somebody that will help them to like interpret and stuff like that. Along with that, there's going to be new eligibility rules which will help to make changes to help the system to be more efficient, sustainable, and well managed. The third key area that was addressed is domestic information sharing. Now, IRCC has clear legal authority to share certain personal information within the department and with domestic government partners. They are making these changes to make information to be more secure and consistent, which will help to improve service delivery and collaboration between the federal and provincial government and also the programs that comes with it. So a few things that the new authorities will do. The first one is that it will allow IRCC to share identity, status, and IRCC issued documents with both the federal, provincial, and territorial government partners through a written information sharing agreement. That's number one. The second one, that it's going to make it easier for IRCC to share clients' information between its own program. And for example, it will use things like permanent residence application data to process citizenship applications, which is great. Another thing it will do is that it will allow for regulations to be developed to share client information across federal departments and agencies for the purposes of cooperation. This is very, very important. To ensure the privacy of people, the new authorities have built-in safeguards to ensure that all applicants' privacy and charter rights remain protected at all times. Information will only and can only be shared with the federal, provincial, or territorial partners who have legal license or allowed to collect that information for specific purposes, and ensure that they have clear written agreements or arrangements in place to do that. The provinces and the territories, they cannot share this information with other countries unless, take note of this, unless IRCC gives them written permission and the disclosure complies with the Canada's international obligations regarding mistreatment. This is very, very serious, guys. Within IRCC, a PIA or a privacy impact assessment now has to be completed for any new use of anybody's personal information. The PIAs will spell out what can be shared, why they can share it, and they will also set limits so that staff can only access what they need for their own work. I think this is a good thing that they're doing right now. The fourth key change was that immigration, document, and application authorities will take into effect. Now, what this means is that the government of Canada now has new tools that they would use to arrange or manage immigration documents such as visas, ETAs or electronic authorizations, work permits, study permits, and other applications. This is done so that it will help the government to respond quickly to emergencies or any unexpected situations, so that they can have everything that they are doing to be transparent, to be fair, and they can be held accountable for anything that they do. They also mentioned that when it is in the best interest of the public, IRCC may even cancel, suspend, or change a large group of immigration documents. They can even pause application intake, or they can even cancel or suspend application processing. So when they say public interest grounds, it includes things like fraud, any administrative errors, or concerns that they have for public health and safety, or even national security. And when they're making that decision, it would not be made by a single minister. Each decision would require an approval by the governor in council through an order in council recommended by the cabinet, and the decisions that are published in the Canada Gazette and reported back to the parliament. And anytime they have to do this, the process has to be followed each time they use an authority. Now, these authorities also allow the government of Canada to make regulations that will describe scenarios where an officer or officers can take similar actions on a case-by-case basis. For example, by reviewing the document holders outside Canada to confirm that they remain admissible or they remain eligible for such applications. Now, these authorities, they don't affect any asylum claims, applications for refugee protection, and they don't give the government power to grant, to change, or revoke status, such as revoking permanent residency and temporary resident status. To get more information about this update, please visit the official Government of Canada's official website, which is www.cic.gc.ca, where you can see all of this information that have been shared with you today on this video listed there. One thing I want to mention on this video is that if you're an international student and you have told the Government of Canada that you have what it takes to come here to study, and then maybe because you don't have money to like further your studies, or you're having one challenge or the other, you now decide because somebody has advised you that you need to just go and claim asylum. Like, please, my advice to you is don't think of doing that, because you will ruin your chances of being in Canada. Canada is no longer smiling. Canada of 15 years ago is not the same right now. Things are changing with the temporary resident thing, with permanent residency, with workers, with permits, and everything is seriously changing. And you don't want to be caught up with things that will put you into a black book with Canada government or Canada immigration system. Because somebody has done this in the past does not mean that it will work for you right now. With this new Bill C-12 law in action right now, I'm telling you, it's a game changer for anybody who plans to take that route, because they are now going backwards to say, no, we will not allow this, and you have only two options, So I'm going to end this video. Thank you so much for watching. I wanted to let you guys know that I decided to make this video because I feel that it is very important for me to share this information with you all, especially those of you who plan to come to Canada from the border, US border, because of things that are happening in the US. Please note what is changing with Canada asylum system right now. And please don't forget to like this video, share this video. And the reason why you need to like this video is for the fact that the more likes this video gets, the more YouTube shares my video to other people who are planning to make an asylum claim in Canada, so that they too can be aware of the changes that are being put into place. Share this video with your friends and loved ones. Like the video, subscribe if you haven't yet subscribed to my channel. Subscription is free, and it also helps me and support my channel so that I can keep making such videos. I do appreciate those of you who are my subscribers. Yeah, I don't take it for granted. I've made some other videos that you should also go and watch. I have a playlist that you can also go and check as well. And I remain Gloria of Canada. I love to share information about life in Canada for new immigrants, newcomers, those who are just moving to Canada, or those who plan to move to Canada, and also those who are already in Canada. So until I see you in my very next video, stay safe and bye.